Okay. Hello, everyone. Good evening. And thank you for joining us today for this important and timely discussion of the recent developments at the International Criminal Court. The overwhelming response in registering for this webinar, representing academia, government, law firms, and civil society organizations, reflects the significance of the issues we'll be exploring today. I'm Hila Kugler-Ramot, the CEO of IJL, and I am honored to be hosting our discussion with two very distinguished speakers, Professor Irwin Cotler and Professor Yuval Shany. Thank you both for taking the time to share your meaningful insights with us today. I would also like to extend special thanks to our co-sponsor, the American Association of Jewish Lawyers and Jurists, our US-based affiliate organization. Today's webinar focuses on the ICC's recent decisions in the situation in Palestine and the arrest warrants issued. IJL has been actively engaged with the ICC since 2009. In the current proceedings as well, we submitted a detailed amicus brief. Our submission, along with those from numerous states and organizations, highlighted crucial legal and procedural challenges to the current ICC proceedings, in particular jurisdictional issues. Unfortunately, the decisions rendered by the court did not address many of these concerns and have stirred significant turmoil in both legal and political spheres, with potentially far-reaching implications for the court itself. The recent developments are especially alarming when considering the broader context of intensifying cynical attempts to misuse and weaponize international law. Such attempts have also been evident since October 7, aimed at delegitimizing Israel, its right to exist and defend itself. However, this is not only an Israeli concern, it should be a concern of all those who cherish international law. Before turning the floor to our esteemed speakers, please know that we have structured today's session to allow time for audience participation. I encourage you to submit your questions through the Q&A function in the Zoom interface. We will begin with opening remarks from Professor Cotler, providing the context for understanding the broader implications of the recent developments. Professor Shany will then present a detailed analysis of the decisions delivered by the ICC on November 21st, the arrest warrants issued, and explore the implications for the court's legitimacy and effectiveness challenges. Let me now properly introduce our first speaker, Professor Irwin Cotler. Professor Cotler is the chair of the Raoul Wallenberg Center for Human Rights. He is an emeritus professor of law at McGill University and a former Minister of Justice and Attorney General of Canada, a longtime member of Parliament, a constitutional and international human rights lawyer, and counsel to prisoners of conscience. Professor Cotler is also a lifetime member of IJL. Professor Cotler, please.
Thank you for those kind words of introduction. May I commend you and the IJL for convening, as you put it, this very timely and significant forum, and for your effective amicus interventions before the court. I'm delighted to join Professor Yuval Shany, who I regard not only as a leading scholar practitioner from Israel, but a leading global scholar practitioner of international human rights, humanitarian, and criminal law. What I'd like to do today is to share with you a narrative of Canada's and my involvement with the ICC as a backdrop or looking glass into assessing and appreciating the recent actions by the special prosecutor to seek arrest warrants and the decisions of the chamber, pretrial chamber, to in fact issue arrest warrants. Beginning with the 90s, let me say, in discussing Canada's and my involvement, in the 90s, then as a law professor, I served as a special advisor to the Canadian government on its path towards advocating for an international criminal court, was present in 1988 at the creation, as I say, at the Rome Treaty in Rome, and then joined other Canadians and indeed the international community to celebrate the appointment of Philippe Kirsch, who was a close colleague and friend of mine, as the first president of the ICC. In 1999, I was elected to Parliament, and one of my first acts early in 2000 was to co-sponsor legislation, the War Crimes and Crimes Against Humanity Act, to domesticate the Rome Statute in Canadian law and provide Canadian courts and Canada with universal jurisdiction. In 2002, together with the Parliamentarians for Global Action, we convened the first ever parliamentary assembly for an international criminal court. And in 2005, as Minister of Justice and Attorney General, I initiated the first ever prosecution of a Rwandan genocidaire at the time, anchoring the prosecution in the Rome Statute and international criminal law. Fast forward to 2015, where we submitted a brief then with respect to the issue of jurisdiction, saying that the ICC did not have respective jurisdiction over Israeli nationals because Israel was not a state party and Palestine did not have the constituents of a state under the Montevideo Convention. But even if it had, it did not have the authority to delegate criminal jurisdiction over Israeli nationals to the ICC, because that would be in breach of the Oslo Accords. Fast forward to 2017, when, and this becomes very relevant to the analysis, I was appointed to an independent panel of experts established by the Organization of American States to look into whether there are reasonable grounds to believe that crimes against humanity were being committed by Venezuela. We determined in 2018 that 7 major crimes against humanity were being committed. And following that, the then Foreign Affairs Minister of Canada, Chrystia Freeland, initiated the first ever collective referral of the state party, i.e. Venezuela, to the International Criminal Court for prospective investigation and prosecution. In 2021, Karim Khan was elected as a special prosecutor for the ICC. We in Canada supported his candidacy, and then began, I supported it as well, a close relationship with Karim Khan, both Canada and myself personally. In 2022, and this becomes relevant, the Rwandan Center for Human Rights, where I act as international chair, invited Karim Khan to deliver the Elie Wiesel lectureship in human rights. In 2023, in December, following the mass atrocities of October 7th, we arranged for Karim Khan to visit the kibbutzim in the south, whereupon he shared his anguish and agony at what he heard and what he witnessed, and at the same time spoke of Israel having a robust, independent judiciary, which could be counted upon to engage in any appropriate accountability. In February 2024, on behalf of the Rwandan Center for Human Rights, we submitted a very extensive legal brief to Karim Khan at The Hague, over 1,000 pages of detailed and documentary evidence with respect to the involvement and complicity of Hamas leaders in the mass atrocities, and called for their prosecution. All this is a looking glass into what occurred recently with Karim Khan seeking arrest warrants against Israeli leaders, and the pretrial chamber then responding with those arrest warrants. And recently, in a discussion with our Canadian Prime Minister, who was asked, will Canada enforce the arrest warrants? His answer was, in the backdrop of what I said, well, Canada, as you know, is a founder of the court, and we will abide by all decisions taken by the court. I recently met with the Prime Minister after that statement, several days ago, in fact, and shared with him what I regarded as the standing breaches by the special prosecutor and the ICC of foundational principles of the ICC statute, which would mandate Canada as a supporter of the court to call out these actions and hold them to account. Let me very briefly mention those foundational principles of which the special prosecutor and the court has been in breach of, and also continue the narrative. The first is the complementarity principle, which, as we know, means that the ICC will not substitute its judgment where there is an independent judiciary, independent legal system that is able and willing to undertake the necessary investigations. Now, this brings me to the second principle, and that is the principle of cooperation, something that Karim Khan, proudly espouses. And therefore, I helped facilitate, at his request, meetings with the Israeli leadership to take place in May 2020, so that the principle of complementarity could be engaged at the same time and in context with the principle of cooperation, and so that Karim Khan could share with the Israeli leadership and they with him the steps to be taken to both adhere to the principle of complementarity and the principles of cooperation, which brings me to the last principle, and that is that of equality before the law. And here the Venezuela connection that I referenced earlier becomes particularly timely and pertinent here. Karim Khan, in April of 2024, went to Venezuela, and after discussions with Maduro, decided not to issue arrest warrants, even though our independent panel of experts that I referenced before had issued a third report saying these crimes against humanity were continuing, and in particular, in the run-up to the election in Venezuela that took place in July, that was neither free nor fair. It was accompanied by a total dismantling of any vestige of any independent legal system, judiciary, and the like, the arrest of those who sought to be candidates in et cetera, et cetera. In other words, Karim Khan entered into an agreement not to issue arrest warrants, though the Venezuelan leadership was in standing breach of all principles of complementarity and the like, let alone its own crimes against humanity, but did make a decision to proceed to call for arrest warrants against Israeli leaders, even though, as I mentioned, the principles of complementarity and cooperation were being respected by the Israeli leadership. Let me just close by saying, because at this point, Israel has appealed the decision, that there are three things that have caused me some concern in the Israeli approach. The first has been that it has not yet moved, and I recommended this even before the issue of arrest warrants were even spoken of, to establish an independent commission of inquiry, or even better still, an independent prosecutorial investigation based on the two charges that Karim Khan was then led to lay regarding Gallant and Bibi. In other words, the principles of going after the particular defendants and the particular crimes. Regrettably, that was not done and has not yet been done, and I would recommend now that that should be done. Second, that Israel should not, as it is sought to do, and I cautioned the Prime Minister when I met with him back in May, after Karim Khan made the decision to issue arrest warrants. In other words, if you recall, there was a very peremptory move by Karim Khan. I had facilitated meetings with him and the Israeli leadership to take place on May 20th. At the last minute, Karim Khan canceled that visit and called a press conference in which he announced the calling for arrest warrants. I felt that was a breach by Karim Khan of both the principles of complementarity and cooperation that he had espoused. I was then in Israel at the time, and the Prime Minister said that they were then going to portray Karim Khan as being the anti-Semite that he was. And I said, no, he is not an anti-Semite. And if you do that, you'll deflect the proper critique that can be made of his decisions. And finally, I said then, and repeat now again, one should not call out the ICC as being anti-Semitic. Rather, one should go ahead and critique it for the breaching of its own foundational principles by both the special prosecutor and the decisions of the pre-trial chamber. Admittedly, those decisions have incentivized anti-Semitism, and we see it in the manner in which it has contributed to the weaponization of international law, which has been singling out Israel for selective opprobrium and indictment, whether it be decisions of the UN General Assembly, whether it be decisions of the ICJ, and whether it be decisions of UN special rapporteurs and the like. But all of these should be criticized on the merits. One can even make the argument that I have made that the international institutions have been responsible for laundering anti-Semitism under the protective cover of the UN under the authority of international law, under the culture of human rights, and under the framework of anti-racism. That can be made on the merits, but one should not, with regard to these specific indictments, begin to indict either the special prosecutor or the ICC as being anti-Semitic. I'll close by saying that right now, with a new president-elect in the US, but with a bilateral condemnation by the US of the decisions of the both special prosecutor and the court as being quote-unquote outrageous, by condemning what they have called the false moral equivalence between a genocidal terrorist organization like Hamas and a democracy, however flawed it may be, like Israel. The path forward at this point is going to be very dynamic in terms of the political configurations. But I do believe that Israel has a strong case on the merits, should make that case on the merits. Turn it over now to Yuval Shany, who's the best person to make that case on the merits, and we'll proceed from here.
Thank you very much, Professor Cotler, for these illuminating remarks. Before turning to Professor Shany, I do have the honor of introducing him properly as well. Professor Shany holds the Hersh Lauterbach Chair in International Law at the Hebrew University of Jerusalem, where he previously served as Dean of the Law Faculty. He currently serves as Senior Research Fellow at the Israeli Democracy Institute and as a Research Fellow at the Ethics in AI Institute in Oxford. Professor Shany's experience includes serving as a member of and chairing the UN Human Rights Committee. Yuval, please.
Thank you, Ila, and thank you very much, Irwin, for this very important and interesting contextual comments. And yeah, I mean, being in the room where it happened, of course, adds a very important perspective. So let me, what I thought could be useful in the limited amount of time that I have before we go into Q&A is to give a very quick rundown of the dates. I mean, this has been actually a very long saga, and part of the I think part of the differences in perspective between Israel and some of the court's supporters are when do you start relate to when do you actually start the count. Israel is saying the court has rushed to issue these arrest warrants, and I share Professor Cotler's criticism in this regard. But I should say that supporters of the court say, no, this has been actually a very, very lengthy investigation, and therefore the court has, if the court has to be criticized, it is for moving too slow on this process. So that's the first thing that I want to put it into a temporal context. The second thing I want to deal with is the specific sequence of events that started from 20 May when the prosecutor has announced on CNN the intent to bring forward the arrest warrants for Netanyahu and Gallant, but also for three Palestinian Hamas leaders, Def, Ania, and Sinwar, eventually only bringing forward a case against Def, and I'll then comment on this. And then I will say some things about the legal challenges that are currently in place, the decisions that were issued on November 21, and the perhaps some of the implications going forward for Israel and for the court. So let's see how can we do it in a relatively short time frame. So the saga of Israel, Palestine in the court is not something that started after 7 of October. This is really a story that has a very long beard, as we say. The Palestinians have tried to reach the court already in 2009. In January 2009, so we are talking about a saga that started 15 years ago, more than 15 years ago, almost 16 years ago, when the Palestinians were making allegations concerning the way in which the IDF conducted a military operation in Gaza. That is what has been termed by Israel Cast-led, the 2008-2009 military operation, in which allegedly, and these allegations do repeat themselves from one round of violence to the other, in which allegedly the IDF used excessive force and violated principles of IHL. The Palestinians tried to bring this before the court. At that time, the prosecutor was a different prosecutor. It was Luis Moreno Ocampo, the first prosecutor of the court. who had reviewed these allegations and eventually decided in 2012, so that means 3 years later, that Palestine is not a member state. It doesn't have the status of a state under international law as it stood then. It doesn't have, within the UN system, it is recognized as an observer, not as an observer state. And therefore, the ICC cannot deal with a case which is based on a referral by an entity which is not a state under international law, thus closing the first chapter of the saga. But there have been, as we say, to be continued, and it had been continued. And actually, the first thing that the Palestinians went to do after this April 2012 decision by Ocampo has been to go back to the United Nations General Assembly. And on a very historic date, 29 November 2013, 29 November is the date of the partition resolution, and is celebrated in the UN since in the last few decades as the day of international solidarity with the Palestinian people. On that day, they were able to obtain from the General Assembly a resolution that recognized Palestine as an observer state in the United Nations. And that recognition effectively opened the door for Palestine to then try, on the basis of that resolution, to seek membership in a variety of international organizations, including in 2015, less than 3 years later, membership in the International Criminal Court. That is, to join as one of the member states in the International Criminal Court. And the Assembly of State Parties at that time has accepted Palestine as a member state, with I think only 2 states making reservations, Canada being one of them, Germany being another one of them. But this was not seen, there was general support for that proposition, and Palestine joined in 2015 the court. Immediately after joining the court, even a few weeks before joining the court, Palestine also already requested the court to start an investigation into the violence in Gaza in 2014. So this is the next major military operation in Gaza, which is called Protective Edge. This is how the Israeli military called it. Again, allegations of excessive use of force in Gaza, but this time also requesting the court to look at other practices of Israel in the West Bank, including administrative detentions and the construction of settlements. Palestine goes on in 2018 also to make what is called a formal referral, where they invoke their right as a member state to, in a way, force the matter on the agenda of the prosecutor, so it becomes from a discretionary investigation that the prosecutor may adopt or not, to actually a requirement for the prosecutor either to proceed with or to give reasons for not proceeding with the investigation. In 2019, the previous prosecutor, Fatou Bensouda, decides that on the basis of a 4-year preliminary examination, where she has looked into the various allegations made by the Palestinians concerning violations of the rules of the laws of war in Gaza in 2014, also around the demonstrations on the Gaza border in 2018, what is called, the Palestinians call, the Great March of Return. And on the basis of the information that she has on Israel's settlement policy, she would like to open officially an investigation, a criminal investigation into the potential criminal responsibility of various Israeli nationals with respect to these violations. She would also look in parallel at the responsibility of Palestinians for violations of international law committed by Palestinian militant groups in Gaza, especially rocket launching by Hamas towards Israeli citizens. So this is where we are. This is where chapter 2 of the saga had been written. And in that context, the Palestinians were able to basically get their case before the ICC and get the ICC to move from just reviewing an issue at a somewhat informal and preliminary level to opening a formal investigation. But the previous prosecutor, I would say, was quite careful in that she knew that the Israel-Palestine situation, or the Palestine situation, does raise unique legal problems along the lines that Irwin mentioned before, specifically with regard to the status of Palestine as a state, which has been accepted by the member states, but certainly has not been accepted by Israel. Israel does not recognize Palestine as a state, as do as other states. Some of the other states, including some of the other member states, do not recognize Palestine as a state. So there was the question of the status of Palestine. And then there was this issue with the Oslo Accords, which Irwin mentioned. This is, it seems to be a technical issue, but it's rather a very fundamental issue in international law, which goes to the theory that underlies the International Criminal Court. Is this a court whose jurisdiction emanates from above, from the fact that it is a representative of the international community, and therefore any state can trigger the activation of its jurisdiction, or does its jurisdiction come from below? That is, from an act of delegation that was made by a state party. And the argument that was made by Irwin at the time, and by Israel at the time, and by others who have intervened in the case in one stage or the other, was that Palestine could not delegate to the court more than it had had. And since the Oslo Accords established in the early 1990s, early mid-1990s, the Palestinian Authority as an entity with limited powers, effectively containing the power to govern some parts of the occupied territories and to exercise criminal jurisdiction over Palestinian nationals, but not over, or Palestinian residents, but not over Israeli nationals. The question was whether Palestine could delegate to the court the power to introduce criminal proceedings against Israeli nationals. So the prosecutor was concerned about this, these issues. She thought that it could complicate the case going forward. So before taking the next step of continuing with the investigation and maybe even in the future issuing arrest warrants, she resorted to an exceptional procedure that exists under the Rome Statute, Article 19, Paragraph 3, and that is request the court at the preliminary stage to weigh in on the question of jurisdiction, so that before she continues with the investigation, she has the court's position on jurisdiction. And in early 2021, the pretrial chamber, which is differently composed than the current pretrial chamber, has issued a decision which takes the view that the court does have jurisdiction to review the Palestine situation on the basis of the membership of Palestine in the Rome Statute that establishes the court. The court said, essentially, we are not making a decision whether Palestine is a state for every purpose in international law. This is not our function, but we can safely rely on the United Nations resolution accepting Palestine as an observer state, and on the states parties' acceptance of Palestine to the Rome Statute. And on that basis, Palestine is a member state, and the case against involving crimes committed in the territory of Palestine can continue. And they also asserted that for the purposes of what are the territories of Palestine, they will follow the standard UN approach, which is all the territories that Israel occupied in 1967, of course, with the exception of the Golan Heights, but with regard to the West Bank, East Jerusalem, and the Gaza Strip. But on the issue of the Oslo Accords, here there was a split among the three judges that reviewed the case. One judge, Judge Kovacs, the Hungarian judge, accepted the claim and took the position that the court does not have jurisdiction over Israeli nationals by virtue of the Oslo Accords that restricted the power of the Palestinian Authority, and they cannot confer to the court more powers than they have. The two other judges didn't rule differently. They simply ruled that this is a premature issue. This is not an issue that the courts need to decide now. There are, at this point in time, there are no specific requests for arrest warrants against any Israeli national. Therefore, they decided that the matter would be discussed at a later point in time when arrest warrants are requested. At that point in time, it would be for the court to decide the issue. So effectively, what the court did was reject the objection that emanates from the dubious status of Palestine under international law, but defer or kick the can forward with regard to the Oslo Accords issue. And on that basis, the prosecutor proceeded with the case, and in 2021, she officially opened an investigation and notified Israel about the opening of an investigation. This is a significant point to which I will return momentarily. At that point in time, under the Rome Statute, although Israel is not a member state, every state who is relevant to an investigation is notified about the opening of investigation with the purpose of allowing that state to claim complementarity, which, like Irwin said, is a foundational and central principle in the Rome Statute. The prosecutor notified Israel of that possibility. Israel at that time, we do have some lack of clarity as to what Israel did in response. It's quite obvious that Israel did not invoke complementarity in a formal sense. It did ask for more information, which never came. And effectively, no complementarity was invoked officially at that time. And the investigation continued. Here, we basically closed the third chapter of our saga. So the investigation has been opened. It has been approved by the court. Israel did not invoke complementarity, but the case was somewhat on the back burner. And in fact, Karim Khan, when he joined the court, did indicate that this is not a priority case for him. At that time, there were other cases that were more interesting or more urgent, and that may also have to do with his perception that Irwin alluded to, that Israel does have a legal system and they are looking at some of these issues. Indeed, Israel was looking, I should say, into many of the allegations that related to the Gaza situation. Where Israel was not looking, of course, is directly at issues relating to settlement activity, which is not criminalized under Israeli law. There could be some specific exceptions on specific land grabs that could be outlawed by Israeli law. Now come, of course, 7 October, the tragedy of 7 October, and the renewed involvement of the court. And what happens after 7 October is that and Karim Khan is receiving a number of new referrals by member states, inviting him to look at violations of international law committed by Israel in the recent war in Gaza. At the same time, Israeli victims associations and other international lawyers are directing his and his office attention to the atrocities committed in October 7, and he visits the region a couple of times. He goes to the Rafah crossing. He has a press conference in Cairo. He also then later comes to visit Israel, visits the kibbutzim, goes also to Ramallah, issues a number of statements. And as we know, he has been in the month following October 7 and his visits in late 2023. Him and his office are in ongoing contact with Israeli officials, including with a view to receiving information from Israeli officials about conduct of investigations in Israel. I'm digressing for a minute, and I would say that Israel has responded to October 7 by opening a number of investigations, both into the atrocities committed by Hamas and Hamas supporters on October 7th, but also opening a series of military and criminal investigations into some conduct undertaken by IDF soldiers. But there has been no, as we know, there has been no commission of inquiry established to review more broadly neither the events leading up to October 7 but also the way in which the Israeli military responded to October 7. And here comes the fateful date of May 20, when the prosecutor, at something which catches Israel by surprise, especially in light of the planned visit to Israel that the prosecutor was supposed to hold in late May. He goes on CNN and announced the issuance of arrest warrants. And that is seen both as a surprise because there were no indications that this was about to happen. And in a way, it went against the ongoing dialogue between the office of the prosecutor and the Israeli Ministry of Justice. But also, like Irwin said, because of the significant issues of complementarity that arise in this context. Now, I will, in the interest of time, I will go directly to what happens after 20 May. So the first thing that happens after 20 May is that the UK on 10 June submits a case to the court, basically a request to the court, asking the court for a permission to submit what is called an amicus brief pursuant to Rule 103 of the Rules of Court, and to basically invite the court to look at the question that the 2021 decision decided to defer to the moment in which arrest warrants would be issued. And that is the question of the Oslo Accords and their impact on the court's jurisdiction. So this was something that was not decided at the time. At the time, the court said this would be decided when arrest warrants are issued. The United Kingdom has requested the court to make representations on that issue. And the court accepted this in late June. And not only did it accept the UK request to submit an amicus brief, it also invited, well, not really invited, but it also indicated that it will be willing to review other requests by other interested individuals, states, organizations, and the like, to weigh in on the issues before the court, without actually limiting even the scope of issues that could be discussed in these requests for amicus brief. And indeed, there were more, about 70 amicus briefs that were requested and submitted to the court. And this has effectively put the proceedings on hold for a number of months until effectively the decision that was issued in November. And the court has been criticized by the pro-Palestinian groups and commentators that it has, in a way, abdicated its responsibility to deal quickly with the issue, expeditiously with the request, and that the court is dragging its feet. So we were effectively expecting the court to issue a decision on the question of jurisdiction, on the remaining major question of jurisdiction that was before the court. A, because the case was left hanging by the previous pretrial chamber. B, because there was permission to submit amicus curiae briefs. And C, because in September, Israel itself did the exceptional move of seizing the court directly, holding that the court does not have jurisdiction to review the case against Gallant and Netanyahu by virtue of the Oslo Accords issue, also mentioning Israel's traditional opposition to the idea that Palestine is a state, or that in the bilateral relations between Israel and Palestine, Palestine should be considered a state. Israel also, in its September brief to the court, also raised again the issue of complementarity. And here Israel made the following argument, which is quite, I think, important and interesting. And the argument is such: the 1 month extension that was given to Israel in 2021 covers the investigation that was open in 2021. It could not have been also a notification that would cover events that transpired 2 years later, and certainly could not have been investigated by Israel in 2021. And thus, if the prosecutor was now changing the focus of investigation from events that took place 10 years ago or 6 years ago in a specific context in the West Bank or on the Gaza fence or in Operation Cotler, and is now reviewing the current war in Gaza, which has very different features and also, of course, involves different actors because not all decision makers. Netanyahu is a permanent fixture, unfortunately, according to many Israelis. But the Minister of Defense, for instance, of course, was not in office then. The IDF leadership was not in office then. The Hamas leadership was not in office then. Some of it. So the idea is that you can actually take a notification on one set of crimes, alleged crimes, and then extend it to a very different set of crimes, effectively basically renders the Israel's right to complementarity illusory. So the claim was that the prosecutor should have given Israel, when he decided to open a criminal investigation again, should have given Israel a forewarning and allowed it to claim complementarity. So these were the two allegations that were made in September. In its November decision, the court rejects both Israeli claims, ignoring completely all the mass amicus briefs that the court received. All the piles of documents that the court received were ignored. Essentially, the court says on the Article 19 issue on the jurisdiction, basically, Israel does not have standing to claim jurisdiction under an argument, quite a particular argument, that the article that Israel invoked, Article 19(2)(c) of the ICC statute, is not the proper vehicle to raise the argument. So really on a very specific technicality, I think the court was wrong on this, but that's another matter. The court does not assert that it has jurisdiction, as I believe and Israel believe. I think it must do under Article 19, paragraph 1 of the statute, but rather says Israel doesn't have standing to argue jurisdiction, but it could raise its jurisdictional arguments at a later stage of the process. So on that basis, on a procedural basis, in a very short decision, it throws away the jurisdictional objection without dealing with the concerns that have been invoked in the last, I would say, almost 10 years concerning the court's power to even review cases involving Israeli nationals. And then on the question of Article 18, the complementarity issue, the court rejects the interpretation offered by Israel and essentially says it's the same. It's the same conflict. It's a conflict in Gaza between Israel and Hamas, and therefore the prosecutor can rely on an earlier notification. Again, I think a highly formal decision, which does not really look at complementarity as a dynamic framework of cooperation and division of labor, but rather as a box that needs to be ticked, and in my view, in ways which are not compatible with the object and purpose of the institution of complementarity. So this is where we are with regard to the procedure. Both of these decisions, I would say, are on appeal. Israel has appealed both of these decisions, both on jurisdiction and on complementarity, to the appeals court. It appealed them through two different channels. The prosecutor is trying to block these appeals. The court would have to decide them rather soon, and we will see what happens with those procedural issues. But it's obvious that the jurisdictional issues are still alive. And like Irwin says, Israel can still proclaim complementarity if it opens a police investigation or a prosecution-driven investigation against Gallant and Netanyahu. The other two decisions, and with this I will move to finish, the other two decisions issued by the court on November 21 is the arrest warrant to Gallant and Netanyahu and the arrest warrant to Mohammed Def. With Gallant and Netanyahu, the court does find a number of grounds which the prosecutor requested for on crimes against humanity and war crimes. The central charge, I would say, is starvation of civilians as a method of war. This is a somewhat legally contested category because it only applies in order to be able to charge it. The prosecutor would have to show that the conflict between Israel and Hamas in Gaza is an international armed conflict. In IHL, there is this division between international and non-international armed conflict. There is a division of views between experts how to classify the conflict. The prosecution and the court accepted this, has adopted the less convenient framing for Israel, and that is that with regard to Israel, it's international armed conflict, but with regard to Hamas crimes against Israelis, this is non-international armed conflict, which is somewhat of an odd legal construction, and I would expect to see a lot of litigation around this specific issue. With regard to crimes against humanity, which does not depend on this distinction, I will note that there have been allegations of murder, of cruel treatment, and other inhumane act. The one perhaps most serious allegation brought by the prosecutor, that is the crime of extermination, was thrown out by the court, which is interesting because this is the allegation that most resembles the charge of genocide that we hear in the International Court of Justice. And here the court says the prosecutor did not, at this point in time, submit enough information to substantiate the crime of humanity of extermination, which involves mass killing. And that may have to do with the difficulty of showing at this point in time that large numbers of civilians in Gaza died as a result of malnutrition or dehydration. With regard to death, the charges are also crimes against humanity and war crimes, and they focus both on the massacres committed on October 7, but also the mistreatment of Israeli hostages. Of course, death, as we know, is not with us anymore. So the very decision by the court to continue with the proceedings has been criticized as somewhat of a PR stunt designed to show that the court is balanced and is actually prosecuting both Israelis and Palestinians. There's not going to be, as we know, a trial against Deaf, who Israel has confirmed has died in an attack in Gaza. Now, where does that lead us? And with this, I will close. Implications for Israel. This is, of course, a very bad development. However you spin this, the fact that your prime minister and minister of defense, former minister of defense, have been charged with war crimes and crimes against humanity in relation mostly with the starvation policy, which is an area where Israel has been, I should say, criticized by its best allies. So this is not something that comes completely out of the blue. There have been obviously many problems and difficulties in that area. Now it has been branded as a criminal project, or at least allegedly criminal project. And this is for Israel a major PR disaster, which is bound to increase its international isolation, but also make it more difficult on a practical term for Israel to collaborate with allies, to receive arms, ammunition from allies. And we are already seeing today there's been an attempt to bring a case against an former Israeli general who's now stationed as a diplomat in Belgium on the basis that he was involved in the deprivation of food in Gaza. He served in that capacity in the IDF, and I'm sure there are going to be many other cases going forward. So for Israel, this is a very bad development, and I subscribe to what Irwin said, that Israel could have done better in terms of setting up an investigation, and at least this could have either avert the issue or at least convince Israel's allies and friends that it is doing whatever it can to look into these allegations. The other issue for the court, this is also a very difficult point in time for the court, and it may be that the court has bitten more than it can chew by tackling Israeli leaders at this point in time. As we know, Trump is in office, is going to assume office on January 20. Within the Trump camp, there are many enemies of the court who in the previous the Trump administration sanctioned the court and are going to go now even more aggressively against the court and its officials, and even against states that support the court. So the court is risking a significant blowback, which is to some extent would be eased or facilitated by the idea that the court has been quite loose with the determination that it has jurisdiction. It issued arrest warrant without first establishing that it has a jurisdiction over the case. It adopted a very thin approach on complementarity. And it also advocated, and this is not related to Israel, but it is advocated in recent years a very expansive view concerning the court's overriding power vis-a-vis immunities that states have traditionally in international law, and the combination of being loose on jurisdiction, thin on complementarity, and aggressive on the issue of immunities is going to cause even supporters of the court to doubt to some extent the general direction. The fact that the court is also dealing with a sex scandal that directly involves the prosecutor is, of course, not making things easier for the court. And I think the court would do well to look for a way out. And a way out, the only way out at this point in time would be for Israel and the prosecution to reach some agreement about modalities for investigation that could satisfy complementarity in ways that would parallel the ways in which Maduro and the court has reached an agreement, and before that the Colombian government and the court had reached an agreement. And that's probably the most positive way out of this. If we have more time in the Q&A, we can discuss other implications for other cases before the ICC and other bodies, but I will stop here in the interest of time.
Thank you very much, Yuval, for this thought-provoking and very structured analysis. As you can imagine, and not surprisingly, we have many questions from the audience. So in the interest of time, we'll jump on to present several of them. A couple of our participants have asked about Moshe Ya'alon's recent comments accusing Israel of engaging in war crimes. What would be the implications of such comments made by Moshe Ya'alon or other officials of that status?
So do you want, Irwin, do you want to take this? Do you want me to take this? Hila, what do you say?
If I have anything to add, I'll add.
So
Right.
Yuval, the floor is yours.
So Ya'alon's comments were effectively that Israel is engaged in a policy of ethnic cleansing of northern Gaza. This is not directly related to the current ICC charges that charge a policy of starvation, but it is in the same, I would say, zip code of issues, because there have been allegations that the food in Gaza there have been restrictions on entry of food into certain areas of Gaza in order to encourage the population to leave from one place to the other. Now, the issue of the pictures coming out from northern Gaza looks very, very dire. I mean, it does seem as if there is wide-scale destruction there, and there has been also interest. It's not denied. I mean, this has been the policy that the civilians would evacuate northern Gaza and move into Gaza City proper. Now, the Israeli authorities deny that the purpose is to render northern Gaza inhabitable or to prevent the return of civilians to northern Gaza. And if this is the case, and the burden of proof would be ultimately on Israel in this case to show that it is allowed people to return, and it is not excessively destroyed property and infrastructure in ways which would not be justified by military necessity. But if Israel meets that burden, then we cannot really talk about ethnic cleansing. Of course, where Ya'alon does have a point which we should consider is that some of the more aggressive statements that have been made by government officials are compatible with an ethnic cleansing narrative, because they are talking about resettling the northern Gaza and of having the population of Gaza decrease, or teaching a lesson, or the general's plans. I mean, all of these code terms are not compatible with international law. But the IDF spokesperson, who has generally been quite credible throughout the conflict, flatly denied that this is the purpose, flatly denied that the general plans of basically or clearing or destroying parts of northern Gaza is being implemented. Basically said that this is a temporary evacuation. And unless we have, we are looking at it from a distance, we have no direct insight into what's exactly is happening both in the field and in the IDF decision rooms, I have no specific reason to reject what he's been saying. So I would say we will have to follow this and monitor this situation close, because it does really look very concerning.
The only thing I would add, that I agree with what Yuval said, is that the statement by Boogie Alon, regrettably, and I see the way it resonates here in Canada and the like, tends to contribute, however inadvertently, to the overall process of the weaponization of international law and international institutions. We should not forget that there are separate proceedings before the ICJ, both with regard to allegations of a genocide, but also a commission of inquiry that has been set up. So these statements all converge. While we're talking now about the ICC, we have a variety of proceedings by UN special rapporteurs, by the ICJ, by commissions of inquiry. And when a statement that is made like that by Boogie Alon, it's seized upon and further contributes to this weaponization of international law. And the other thing that, as Yuval mentioned, I found it very disturbing, the statements that have been documented and collected in the genocide proceeding before the ICJ, of statements made by Israeli ministers and the like, which regrettably, created a certain, again, inadvertent, but in its effect, created a climate of the fact that Israel was engaged in ethnic cleansing, starvation, and the like.
Just to a point which is maybe obvious to the Israelis in the room, but I don't know how close others are following, there is intensive fighting in northern Gaza, and there have been dozens of Israeli soldiers that died in combat in northern Gaza in the last few weeks. So this is not a situation which is, it's not far-fetched to claim that this is an active war zone, and on that basis, civilians have to move until the war in that area recedes.
Thank you. Another question that we have is from, pointing to implications on other countries. Is there a risk that now countries like the US, UK, and Canada, Australia also will be taken to court, action taken against their leaders? Israel has similar legal systems to theirs, and they have also been involved in urban combat. Actually, the prosecutor has even investigated some of them. Should Israel's case be a warning to them?
Well, I think the UK and the US have room for concern because, like you said, both of these countries were subject to preliminary examinations by the court relating to their practices in Afghanistan and Iraq. I wouldn't say in general that the record of internal investigations is more impressive than the Israeli ones. They haven't really prosecuted any leader or any senior military official. And some of their investigations were very drawn out, and they're also so I would say that if this is now the standard, and basically you're expected to prosecute your prime minister or president during a war, while a war is still pending, for war-related policies, this is a standard that I don't think any state in history has ever met. And if this is the standard, all countries that are involved in these asymmetric conflicts that raise very difficult dilemmas as to how to deal with terrorism and with urban fighting, they are exposed to a level of legal risk that did not exist before. So of course, you could say that Israel has been, some of the statements in Israel have been perhaps particularly careless, and maybe Israel has been longer on the spotlight. But there is, I would say, a genuine concern about where the court is heading, both with regard to the way it applies complementarity, but also with the way it deals with immunity issues.
Yeah, just to add, Karim Khan, when I expressed my concern about the matter of the prospective issuance of arrest warrants, at the time we were in ongoing discussions, and he said to me, well, Irwin, nobody is above the law. And I said, that is true. That also applies to the process of the special prosecutor, who has to observe due process, and the court that has to adhere to its foundational principles. And that is why one has to be concerned that if one applies it, the principle known as above the law, as Karim Khan has done so, but not taking into account all the other concerns in the manner in which he has proceeded. We haven't gone into the issue of the evidence, but I can tell you that the evidence itself has been seriously misinformed, uninformed, flawed, and false and misleading. And that has been, critiqued in a number of the amicus briefs. So I think the evidentiary issues are also going to join together with the legal issues, and the special prosecutor and the ICC will have to guard against trying to extend this to other Western democracies who are now going to be on greater alert, and in particular now with the new American administration, but here bipartisan support here now for sanctions of the court. And so I think we're going to see a different dynamic evolving. My whole approach is I'm a strong supporter of the ICC. Canada was a founder of the ICC, but it has to adhere to its own foundational principles, and it has been breaching those foundational principles.
Thank you. We'll take two last questions. The first one on the complementarity. With the test established of the same person, same conduct as you referred to, what will it take for Israel to make a substantive claim? Is the inquiry commission enough in that sense?
Yeah, I guess that's part of the problem. I mean, the reason why Israel has been so aggressive in claiming that they have a right to notification is that the standard for review at the beginning of an investigation is a more flexible standard, where you have to review a pattern of criminality regarding a category of suspects, but don't really have to zoom in. So if that was the standard, yes, a commission of inquiry would have sufficed, provided that that was an independent commission of inquiry that could also make recommendations regarding follow-up criminal processes, as it happened in Israel on a number of occasions, including after armed conflict or military operations. At this point in time, where we are at Article 19 and there are already arrest warrants, and provided that the court doesn't force the prosecutor to go back, or the prosecutor does not agree to go back, I'm afraid that the only option now on the table is to open a police investigation or a special investigation that is run by the office of the prosecutor, and on that basis to basically look at the individual responsibility of Gallant and Netanyahu for allegations relating to essentially the same conduct, to the deprivation of humanitarian aid in Gaza. The office of the prosecutor in Israel has so far declined to do so, on the basis that it's indeed a very awkward situation, because in Israel the ministry, you well know, Hila, the Ministry of Justice wears two hats. They're advising the government on policy, and they're also applying the law to government officials. And here lawyers were involved in many of the decisions relating to humanitarian aid, which goes also to the point Irwin said about evidence. I mean, if these decisions were vetted by legal advice, it's going to be very difficult to attribute criminal intent to a decision maker that relied on them. But at this point in time, it's going to be quite difficult. But I guess they don't have a choice, but rather appoint someone who was not involved in providing legal advice, like a special prosecutor that, in the United States, we have that institution. And that person who was not part of the decision making or the advice circle would have to look into the criminal responsibility of the perpetrators. This is the option that we have at this point in time. We should have a commission of inquiry, I should say, regardless. I mean, there is a strong public interest in Israel in doing so, but on the Article 19, this is where we're at.
Thank you. Irwin, would you like to add something?
Oh, I share exactly what Yuval said.
Okay, thank you. So the final question that we'll be able to take would be, what do you think or what would you expect the impact of any renewed or expanded US sanctions against ICC personnel or other associated with this case would have?
Well, I think we have to see, of course, what the sanctions are. But I mean, the buzz that we are hearing is that there is an attempt basically to treat the court as if it was a terror organization, in terms of cutting off not only travel for court officials, but also cutting its ability to operate on the international financial infrastructures, basically to maintain bank accounts and the like, and also pressurizing member states that support and fund the court. If this is indeed something that will materialize, the court might not be able to function in the long run. Mind you, the court is already under sanctions from Russia, and having two members of the Security Council, Russia and the United States, join forces in order to put the court out of business is going to put the court in a very difficult position. It will depend, of course, on how much its court supporters will stand behind him and will be willing to assume a price. I mean, what we've seen with France this week, that they have walked back their position on immunity, is not a very encouraging sign for the court. But I should say we do have these, actually, as we are speaking, the Assembly of State Parties of the court is meeting. And I think it's interesting to see what sort of messages are being put forward by the membership to the leadership of the court, both formally and informally, around these issues.
Now, I just added, and again, I share with you also that the combination of both the threat and reality of sanctions re the court and its officials, coupled with it at the same time an independent prosecutorial inquiry that Israel would initiate, those two together would, I believe, give the prosecutor the ladder to climb down and put an end to those arrest warrants, given everything that would be at stake if he were to continue to proceed along the path that he has initiated. And as I said, as more and more evidence comes out about the flawed character, both from a legal and evidentiary point of view, of his proceeding as special prosecutor, I think that will provide the possibility for the special prosecutor to step down and put an end to those arrest warrants proceedings.
Thank you. Unfortunately, we have to conclude. And so before parting, please join me in thanking the IGL team led by Dr. Tabori for orchestrating this significant webinar. And thank you, Yuval and Irwin, for this critical and enriching discussion, and to all of our participants for taking part. We absolutely look forward to seeing you at our next webinar to discuss pressing legal developments. So thank you very, very much.